CJAG is a loose network of professionals in the criminal justice system who share my passion for wanting to modernize and improve the criminal justice system in Nigeria.
Expertise and experience really in improving the justice system.
Iyabode Ogunniran holds a Bachelor of Laws degree from the University of Lagos and a Master of Laws degree from the Harvard Law School.
As we've discussed sexual and gender-based violence also. And we do share practices. Lagos State has done a lot that we're still trying to catch up with. And Ekiti as well is actually quite, they've done quite impressive stuff.
Ethnic, cultural, and religious factors. For instance, the Supreme Council for Sharia Law in Nigeria, along with some legislators from the North, characterized the Child Right Act as anti-culture. Right in this country, but I'm afraid in Nigeria is the more you look, the less you see.
Even the Child Right Act talks about when a child has committed, has been involved in murder, in treason, and all of that. At that level, is a point of departure for the Child Right Act, because the Child Right Act begins to look at custodial, sentences.
Look for more civilized. There are other ways of attending to children than the way it used to be back then. So yes, more education is needed of parents.
Yes, definitely. My first speaker is Commissioner for Lagos State.
Thank you very much. I'll just try and share my screen. Lagos used to be the capital of Nigeria, but that capital had moved to Abuja. However, Lagos still remains the economic capital of Nigeria.
Thank you for that introduction, Babs. Let's just see if everybody's got that screen up now. It's outside of the camera view, approach speed and times of both vehicles that were involved.
Criminal, speaking of passengers, the criminals pose as drivers, and they just pick up innocent and unsuspecting passengers. Before you know, the person is dispossessed of his or her items.
My email address on the chat box, cjaglaw@gmail.com. So do get in touch with me. We have people joining us from really all over, but most of our speakers, I think, are from Nigeria and the UK. So welcome to the Criminal Justice Advisory Group, known as CJAG. My name is Akinyanju, and I am your host this evening. Today, the 5th of November, happens to be the first anniversary of this organization, which I started about October 2020. And actually, the inspiration behind it was the EndSARS protests and the tragic events that took place on the 22nd of October 2020. So CJAG, especially for those who are new, is really a group of specialists that use their collective knowledge, experience, and skills. So these are dedicated professionals and stakeholders to influence government, the judiciary, in improving the criminal justice system. But by way of background, I'm a legal practitioner. I was called to the bar in Nigeria and subsequently qualified as a solicitor in England and Wales. And roughly for the past 30 or so years, I have been practicing criminal law, well, or more to the point, criminal justice, because I actually work in the courts. More recently, my focus has been on family justice, especially with children. But like I say, criminal justice has been at the forefront of what I've been doing. And even in my paid job and also on a voluntary basis, I've been training judges, magistrates, lawyers, even law enforcement, both in the UK and in Nigeria. So just touching more about CJAG, and like I said, it has been running for the past 12 months. We had the inaugural meeting on the 6th of November, 2020, and then we are talking about sexual abuse, survivors of sexual abuse. And one of our speakers then was from the Mirabel Center that's based in Lagos and Sokoto. So following that, we had the first meeting that was recorded. And I must say, by the way, that this all the CJAG events are recorded and they are posted on YouTube. So on the 4th of December, 2020, we had a CJAG session that was on effective prosecution of sexual offenses with one of the speakers, the Ogun State Attorney General and Commissioner for Justice. Following that in February, I hosted a session on children and criminal justice. And that looked at various topics, including age of criminal responsibility, the treatment of children in the justice system, whether as victims, witnesses, or as suspects. And that was a two-part session. I had a criminologist on the first session in February, and then we touched on it again in March. And in fact, one of my speakers today was at that session in March. Then in June, a bit of a deviation, but it was also on the broader criminal justice issues, and that was improving road safety of heavy goods vehicles. And was privileged to have the Commissioner of Transport for Lagos State speaking about that, and a forensic traffic investigator on that matter. In July, a bit of a departure from criminal justice, but I thought I should bring to the attention of colleagues in Nigeria and other stakeholders, because the Supreme Court in the UK had passed a judgment on the case of Okpabi and Shell Nigeria and the Royal Dutch Shell Company. And that case, actually a landmark case, does have implications for oil pollution in the Niger Delta, corporate governance, and also wider environmental law issues, which of course are pertinent as we are talking about COP26 now, and the impact of climate change upon us. So that brings us today, and we are going to focus now on bail. Bail, of course, being once a suspect is arrested or is detained, then the question of what happens to him or her before the suspect is taken to the police station, to court after arrests, and what happens at the court, say, pending trial? Is the person going to be detained until the case is concluded, or is bail going to be allowed? So this is an issue which I thought does need some kind of more ventilation, and just so that we can first of all remind ourselves of the law concerning bail and how it should be administered, and then hearing from the practitioners as to what tends to happen. I would say that for a lot of these events, I would welcome the input of whether members of the judiciary or even retired judicial officers, law enforcement officers, and even members of the legislature, because really they are key when we are talking about what improvements we can make in the justice system, really to serve the public, because I believe that a lot of the issues that are being faced in Nigeria now, especially from a security point of view, is I think does emanate from the justice system, which there is a lot of room for improvement, to say the least, and that falls on us as practitioners, judges, law enforcement, and so forth. So just a brief introduction about the speakers. They are all very experienced and accomplished legal practitioners. So I don't intend to go through, a whole profile or CV. So the first speaker I'll be hearing from is Dr. Iyabode Ogunniran, and she is an associate professor of public law at the University of Lagos. And I'm really grateful to her for being able to come on, because I approached her at short notice, and I know she's been, so I'm grateful that she's been able to come on board. After we hear from Prof, we're going to hear from Cordelia. Cordelia AK, Mrs. AK, is currently Assistant Director, Citizens Rights Directorate at the Rivers State Ministry of Justice. Cordelia is an experienced prosecutor. Until recently, she was actually the Assistant Director of Public Prosecutions for Rivers State. So really, she'll be given her perspective from as a prosecutor. Following Ms. Zeke's presentation of her thoughts, then we'll be hearing from Shiji or Shatoba. Shiji is a legal practitioner who is based in Kogi State, but also retired judge of the Upper Area Court of Kogi State. So he would be, we'll have some perspectives of the judicial point of view when considering bail. And then we have Bulus Atsen, and Bulus is a principal at BY Atsen and Attorneys, and he's also the chairman of the Nigerian Bar Association Abuja branch. So I know that Bulus has been very busy because the NBA conference concluded only, I think, a few days ago in Port Harcourt. I know Cordelia was quite involved in that as well. So I hope that by the end of this session, after the speakers, and they're going to be speaking for a maximum of 15 minutes each, then we'll be able to take questions, which you can, if you have any burning issues, you can put them in the chat function, and then, we'll try and address them in the time we have. So I would be grateful if you keep your microphones on mute, and really we just have the speakers, whose microphones are on. So without further ado, if I may hand over to Dr. Iyabode Ogunniran. Thank you.
Good evening, everybody. You can hear me?
Very loud and clear. Thank you.
Okay. Good evening, everybody. Thank you, Mr. Babatunde Akinyanju, for having me here and listening to you. I'm very, very impressed with what you have done in such a short time. So we go into it. We have a webinar and we're asking the question, is bail free? I'll be looking at it from the academic point of view, looking at the laws regulating bail in Nigeria and looking at it, discussing it, and identifying the gaps and the dynamics. So when we are talking about bail, we all have an idea of what bail is, but basically, bail is a mechanism to secure the appearance of a suspect at a later date and time and at a particular place. It's just to secure the appearance, maybe before the police, maybe before the court. The person may be asked to enter into recognizance, that is a commitment, maybe with or without surety. So that is what bail is all about, just to secure that appearance at the police station or in court. And when we are looking at it, we have to go back to the Constitution. Under Section 36, subsection 4 of the Nigerian Constitution, it says that there says subsection 5, there is presumption of innocence. That means that anybody that is accused of a criminal offense is presumed to be innocent until proven guilty. That means that until you take the person to the court of law and you're able to establish your case, and he also is able to adduce his defense, and the court looks at it and comes up with a judgment, that person is free in Nigeria. So there is presumption of innocence of anybody accused of a crime. That is 36(5) of the Constitution. Then you also have Section 36, Section 35 of the Constitution that says that every person is entitled to his personal liberty in Nigeria. Every person, whether is a man, whether is a woman, whether is a girl, whether is a boy, whether is a non-Nigerian, you are entitled to your personal liberty. And due to that fact, that is the general principle or general provision. Then you have exception, which is saying that if somebody has been, if there is reasonable suspicion that somebody has committed an offense, then of course you can arrest that person. But Section 35(4) goes on and says that if you arrest that person, you are supposed to present that person before a court within a reasonable time. And a reasonable time in the Constitution is 1 day or 2 days. If there is a court within the jurisdiction, 1 day, radius of 40 kilometers, within 1 day, should present that person to court. But if there is no court, then within 2 days, you should present the person to court, so that the court will look at that matter, not a case now. The court will look at, there will be some circumstances that the court will look at, and the court will determine that they should release the person. And in releasing that person, it may be with or without surety. So what I'm trying to establish is that the whole gamut of bail is hinged on the constitutional provision that every person is presumed to be innocent until proven guilty, and Section 35 that says that you have a right to your personal liberty, and that if there is a suspicion that you have committed an offense, you should be taken to court and you can be released by the court. So that is the constitutional provision that we have in Nigeria. But looking at this constitutional provision, you know, when you told me, I had to go on and look at the statistics, because with this you will assume that if somebody is arrested on a reasonable suspicion, or even the person, even if somebody has committed an offense, you still have to investigate. You will assume that, okay, all is well and there is no problem. But I looked at the statistics, and the former Controller General of Correctional Service in Nigeria said that 70% of inmates in the Nigerian correctional centers are awaiting trial inmates. 70% are awaiting trial inmates. So you will wonder that there is a constitutional provision that if somebody is arrested, you should release the person on bail. That is, if it is not a capital offense. We will get to that now. We'll get to that very soon. But the former Controller General, Ahmed Jafar, said that 70% of inmates are awaiting trial. That means that they have not been released on bail. So they are awaiting trial, because if they are awaiting trial and is not a capital offense, with this constitutional provision, they should have been released on bail. So we have to look at that. That is number one issue that we have. Why do we have so many inmates who are awaiting trial in the Nigerian correctional centers? Then we now go to types of bail. And the first one is the police bail, which is an administrative bail. The Police Act, the new Police Act 2020, because before that act, there were a lot of problems with police and bail. But from section 61 to section 63 of the Police Act says that the police, if somebody has been arrested, that maybe somebody has committed an offense and the police arrested that person, or somebody has been arrested without warrant, in the sense that there is a suspicion that somebody has committed an offense, or somebody is found with a housebreaking implement, or somebody is found with stolen items, you know, different ways upon which somebody can be arrested without a warrant, and the person is brought before the police station or before the police. What the police should do is that they should grant bail to that person. Even somebody that has been put into custody, within 24 hours, the police should grant bail. But it says that upon paying a reasonable amount of money. So it's not as if that money is for the police officer personally, but it's just to pay it to the police coffer. And the whole essence is to secure the attendance that, okay, when you pay this money into the police account, when you pay this money, then that means that you will be available on the next available date to the police station. When you are being called, you will be available. At times it may be with surety, or it may not be, or without surety, but a reasonable amount of money. So the issue is, what is a reasonable amount of money in this instance? Looking at section 61 to 63 of the Police Act 2020. What is a reasonable amount of money? So in practice, what happens is that most of the time when you go to police station to secure bail for these suspects, you will see that the police will collect money from you for themselves. So that is another thing that we have seen with the police and the bail, despite what you have in the Police Act. The new Police Act is 2020. So I'm looking at it that in the very nearest future, we'll be able to look at how the police has changed, because what the law says is that it is to protect, that this new act is to protect the right of defendant, the right of victims, enforcement of rights, and so on and so forth. So 2020, maybe in another 5 years, we'll be doing research in this area, and we'll see how the police has fared, whether anything has changed in terms of securing bail in the police station. I also know that in the Nigerian context, apart from the police, we have other agencies that can arrest. For instance, the Economic and Financial Crimes Commission. We have NAPTIP in the area of cases of human trafficking. But I'll be talking about EFCC later, and the dynamics, I'll be talking about it later. Then I think that another thing that we should now look at is the court and bail provisions. The court in Nigeria and the award of bail. And like I said, the basis is the Nigerian Constitution. Then we have the Administration of Criminal Justice Act 2015. And because I'm in Lagos State, I also looked at the Administration of Criminal Justice Law, Lagos State. But what is important for us is that the Administration of Criminal Justice Act is also to improve the administration of criminal justice, speedy dispensation of justice to protect the rights of the defendants, the rights of the victims, and so on and so forth. That's why we have this new act. And because it's a federal act, about 18 states have adopted it as their own laws. So in those states, you may see that the CPC and the Criminal Procedure Act and the criminal procedures or the criminal procedure code may not really, be applicable. And in connection with this Constitution, Section 35 and Section 36, the Administration of Criminal Justice Act states that the court can award bail, Section 165, that it is within the discretion of the court to award bail, but it has to depend on the circumstances of the case, and that it should not be excessive. But when we are talking about discretion and the Nigerian criminal justice system, once there is no guideline and you say discretion, you will see courts exercising their discretion in different ways. That has always been the problem with administration of criminal justice. Once you say discretion of the court and there is no guideline, you will see the court exercising their discretion in different ways. Then it says that bail should not be excessive. It should not be onerous. It should not be punitive. But if we look at the practice, you will see that most times bail can be onerous, bail can be punitive in the Nigerian context. Then it says that circumstances of the case. I will say that in respect of circumstances of the case, we have case laws on this. We have a lot of case laws, on these. The court will always look at the nature of the offense. The court will always look at severity of punishment. The court will always look at the fact that whether the defendant will be able to tamper with investigation and so on and so forth. So those ones, they are laid down, procedure in doing that. But based on the issue that we have in Nigeria with the award of bail, the CJAG divided this grant of bail into three different aspects. It says that if the court wants to grant our award of bail in respect of capital offenses, when we are talking about capital offenses in Nigeria, we are talking about offenses that the punishment will be death penalty. For instance, murder under Section 319, armed robbery under Section 402, treason under Section 37, and some other offenses. If you have been charged for those type of offenses, the ACJA says that the ACJA states that it is that it has to be the High Court who can grant bail in respect of those type of offenses, that it must be the High Court. And it says that in looking at this Section 161 of the ACJA, Section 161, that in respect of these capital offenses, the court, that is the High Court, not the Magistrate Court now, the High Court is the only court that can grant bail. and is only in exceptional circumstances. And these exceptional circumstances is on ground of ill health. You know, ill health is one of it. Another is that if investigation has been going on and it's now over a year, even though it's a capital offense, then the person can apply for bail. And the exceptional circumstances is ill health, because before the ACJA, you have a lot of divergent cases on this issue of bail in capital offenses. In Mohammed Abacha versus the states, even though the defendants apply for bail, because on grounds of ill health, the court said that it could be treated, that it could apply to the hospital, the general hospital, and it could be treated, and therefore it was not granted bail. But in Iyiola Omishore versus the state, the accused person was granted bail. So you have, based on similar offense of murder. So as a result of this, the law now codifies that it will only be, the exceptional circumstances will be on ground of ill health. And a doctor from a government hospital must certify that you are actually ill, and you cannot, such an ailment cannot be treated in their facility or in the general hospital before you will now be granted that bail. So there is that variation now, but it's codified so that you know what you are in for if it's a capital offense. Then it goes on to say that if it's an offense that is punishable with 3 years imprisonment, 3 years imprisonment or above, what will happen is that generally the court should grant bail. But if there is an application, for instance, if the prosecutor brings an application that this person can tamper with the investigation, or this person can avoid trial, then the court may not grant that bail. Then the third one is bail for offenses under 3 years, which generally the court will grant. So you have that division under the Administration of Criminal Justice Act, which, like I said, 18 states have adopted, and the ACJ of Lagos State did not make any distinction to that. And you know, that is understandable because they had their ACJL since 2007, amended in 2011. So it even came out before this ACJA. So they didn't make that distinction. But under this ACJA, you have how you can grant bail in capital for capital offenses over 3 years, punishment, where punishment is imprisonment for over 3 years, and where punishment is imprisonment for less than 3 years. So that is what you have guiding the courts now. But under the ACJA, because of this problem that we now have various provisions now that under Section 33, it says that the police officer heading, the DPO heading the police station must, send returns to the magistrate in that jurisdiction of all arrests, monthly, that, okay, in this magistrate, in this division, or in this police station, this and this are the number of arrests that we have made in a particular month, just to reconcile all these issues. Then the Attorney General of the Federation, if it's a federal offense, should also send, the Inspector General of Police should send returns to the Attorney General of Federation. The Commissioner of Police should send returns to the Attorney General of the state, in respect of arrests and arrests that they have made. Then for the CJ, the chief magistrate must also visit Section 34. The chief magistrate must visit police detention and see the number of people in detention. You understand? And under this provision in Lagos State, I know that many awaiting trial inmates have been set free in Badagry, in so many other places. as a result of this provision. Because once the chief magistrate goes there and asks for the file and see that this person has been here for 3 years, 4 years, and so on and so forth, they are able to reconcile the cases, and they come to court and they are set free. At least I know about what happened in Badagry as a result of this provision. Then the Controller General too of prisons is supposed to send returns to the CJ, that these are the number of inmates that we have in awaiting trial inmates. And I believe that with all these provisions, if we are able to follow it through, that in a few years to come, we should see improvement in our criminal justice system, because we're already seeing that in Lagos State, where I am based. So I will go on finally and talk about the dynamics to bail in Nigeria. We have seen the law on bail, we've seen the Constitution, and we have seen the Administration of Criminal Justice Act. But we have dynamics to bail in Nigeria. The issue of bail not being excessive. In terms of administrative bail, when you're talking about financial crimes, you hear that the court will say that not even administrative bails by the EFCC can take the person to court, and the court will now say that the person should enter into recognizance paying like 1 billion naira. I've seen that one. The person should bring a surety who are senators of the Federal Republic of Nigeria. They should bring a document of landed property in choice places in Nigeria. And you will just be wondering that why should it be so? Why should it be so? When the Constitution says, when there's a constitutional provision that there's presumption of innocence, when you have right to pay your personal liberty, when the ACJA says that bail should not be excessive. So you have tension here. You have tension in the sense that you have the Constitution, then you have the protection of the lives of citizens in the regard that somebody has been there is a reasonable suspicion that somebody has taken away, huge sum of money, economic crimes, financial crimes. So what should the court do in this respect? Another dynamics in the area of national security issues. In fact, in Asari Dokubo versus Federal Republic of Nigeria, the Supreme Court said that national security now overweighs the personal liberty of individuals. So there is also another tension there, because we say that the Constitution is the ground norm. So if the Constitution says that you have right to your personal liberty, why should national security now be over your personal liberty? It's because there is tension. And we have seen leaders of self-determination group in Nigeria who have been arrested, and you will see the terms of the bill that they are very, very excessive. Is because there is a tension between national security and personal liberty. And I was in a magistrate's court one day, and what happened was that I will soon finish. I was in a magistrate court one day, and what happened was that I was there. I went to do a research, and whilst waiting for the magistrate to conclude a case, I just sat there, and there was a particular 2 cases that she called. One was in respect of a house help that stole the money of a madam, and I saw that she granted her bail in the sum of 500,000 naira. And I said 500,000 naira. Then the other one was somebody that sent a text to another person, threatening the person, and the bail was something like 1 million naira. And later on, after the case, I was now talking to the magistrate. She now said that they did not have any choice, that these people, they will bring sureties. They will go and arrange and bring sureties, and that once you grant them bail, you will just see that you won't even see the surety again. They will all relocate from Lagos State. that the only thing they are hinging their appearance on is that huge sum of money that they will deposit, in the courts. So I want to say that we can see the law, but we can see the practice. We can see the dynamics. We can see what the courts are contending with in administering bail in Nigeria. I think I will stop there now and take further questions. Thank you very much.
Thank you very much for outlining the law very comprehensively, and then even giving examples about the dynamics, and trying to actually get into the minds of the judges, as to determining what is reasonable, what could be excessive or punitive, because these are very subjective matters. And I think, as you have pointed out, the need for guidance, not necessarily case law, because case law is case specific, but maybe some guidance would assist. But we'll hear more about that from a judicial point of view. So perhaps if we can now hear from Cordelia AK, especially, like I said, sharing her experience as a prosecutor and latterly as Directorate of Citizens Services. Thank you.
Good evening, everyone. I hope you can hear me.
Yes, I can hear you.
Okay, great. Thank you very much, Babs, for inviting me once more to be part of this webinar. I'm truly grateful. I appreciate the opportunity to share a bit of my knowledge and my experience in this area. Well, you asked a question: is bail free? I would say, first of all, that bail is free, but conditions have to be met. You have to qualify for bail, and you have to show that you merit the bail. Now, this appears to sound like something different from what the Constitution says, because everybody, of course, has the right to personal liberty. But even the Constitution makes provisions, makes some exceptions. So your right to personal liberty more or less ends where the right of the next person starts. So if your right to personal liberty is going to inhibit or is going to affect the right of the next person, then I think that's why we have the laws and rules guiding the issue of liberty, especially when you have been suspected or you're arrested on suspicion of having committed an offense. Now, the prof has thrown up a number of issues, and I'm going to try to look at that and perhaps after saying a few words. I'll try to hazard some answers to some of the questions you've thrown up, but they are quite germane, and some of them are worrisome. Now, yes, the Administrative Criminal Justice Act has done a lot to improve the landscape with respect to the criminal justice in the country. First of all, I know concerning bail, the issue of administrative bail, which is police bail. Previously, it was a situation where if you were detained at the police station, you had to make an application for enforcement of your fundamental rights before you can be released from the police station. But thankfully, with the CJAG now, that's the Administrative Criminal Justice Act, there's provision for you to apply for bail if you are demanded at the station. Well, someone can apply for bail for an individual that has been detained by the police. Now, the Act also makes provision for the magistrate, the court, to actually order that individual to be produced in court, during the hearing of the application for bail. Now, there's an issue that the prof also raised. I think I'll bring it up here. They start taking someone to the court within a reasonable time. Now, the ACJ has made provision, has given room for law enforcement agents to go to the police, to go to the court and ask for more time to detain someone in custody upon the expiration of the constitutionally provided time. So if one is supposed to be and it's taken to court within 24 hours or 48 hours, and that time elapses, the Act has made provision for the law enforcement agents to go to court and give reasons why you still need the person detained in custody, and so the person can be lawfully detained beyond the period that's been provided for in the Constitution. Good thing though is that with the requirement that magistrates, with the provision that magistrates can go to the police station from time to time, it is also possible for magistrates to grant bail at the police station without waiting for them to come to court to apply for bail, after seeing, of course, the list of those that are detained on bail, and they can make inquiries as to why those persons are on bail. So that provision is there. Lawyers can also exploit that provision concerning administrative bail, police administrative bail. It is sad, however, what the talk had read out concerning the sum to be deposited and the fact that it is a reasonable sum, it's not specific. So definitely it shows up a lot of issues that need to be addressed, by the authorities. Now, getting to court. Now, okay, I must mention too, I know Babs is interested in children. I must mention too that for children that are detained, that are arrested in connection with any crime, the police has a duty, has a responsibility to engage their parents, to release the child on bond to their parents, unless there is a possibility that the child might be mixed up with further criminal activity, especially when it has to do with capital offenses. If releasing that child to the parents might actually expose the child a bit more to criminal activity, then they have to think of a proper place of custody for the child. Otherwise, the child is released to the parents on bond, some sort of recognizance. That's automatic. I'll also talk briefly on the issue of bail for offenses less than 3 years. 3 years and more that are non-capital offenses. Bail is supposed to be as of right for such offenses. It's supposed to be as of right, except exceptional, unless exceptional circumstances are shown by the prosecutor. This time, the onus is on the prosecutor to show why the person should not be released on bail. And in a short while, I'm going to give you an insight into what goes on also in the mind of the prosecutor when he receives an application for bail. So, for capital offenses, as Prof has already said, a bail is only to be granted by the High Court, and the onus really is on the person applying for bail to show why he should be granted bail. So you have to show that there are special circumstances. She's mentioned some, the ill health, and also that there has been inordinate delay in investigation and in prosecution of the case. There again, the judge has a discretion. There may be other circumstances, other reasons why the judge would not want to grant bail. But generally speaking, the issue of bail is at the discretion of the court. Finally, the issue of bail is at the discretion of the court. Even if you meet all the conditions, the judge still has a window. There's still room for the judge to decide whether or not bail should be granted in any particular case. Now, what are the usual reasons why? What happens when the prosecutor gets an application for bail? Well, we look at it. And what goes on in our mind, is the mind of the prosecutor, is this person going to be available to stand his trial if he's released on bail? Is he going to interfere with witnesses? Is he going to tamper with investigation? And sometimes investigation, the defense counsel would argue that investigation has closed before the person was charged to court. But there are cases where you still have some of the accomplices of the suspect, of the accused person, or the defendant, you still have them at large. So police is still making efforts to get this person. And when you release the ones you've already got, it can actually jeopardize the rest of the investigation. So tampering with evidence, yes, we have people that tamper with the evidence because of the influence in society. That also is why some persons in the court find it difficult to give them bail. So now they tamper with witnesses, they intimidate witnesses. I've had cases where the witnesses refuse to come to testify because the accused person, the defendant, is out there and sending threat messages through friends. It becomes pressure and it makes it difficult for the prosecution to get the witnesses to come to court to prove his case. So that's part of the reason, what is considered when the decision is being taken whether or not to oppose a bail application. Sometimes you also look at the proximity of the defendant. Some persons live way out of town, far away, and when they are released on bail, they may just go very far from the court jurisdiction. It will take a lot more expense to bring them back, for them to stand a trial. I am a case I still have on that I'm prosecuting is not a capital offense, but it's a case of defilement. 8-year-old girl defiled, she testified, she had to go through examination, cross-examination. We had some witnesses. But after she testified, the judge decided that, okay, he could release the man on bail so that we'll take the remaining witnesses, that he wouldn't intimidate the young girl. Interestingly, he's a religious leader. But it's almost 1 year now, we haven't got the man. He's not been able to get him to come to court. The lawyers that represented him, 2 lawyers, both claim now that they were no longer his client, his lawyers. They were not representing him anymore. He's no longer their client because they come to court for other matters. And they feign ignorance as to his whereabouts. So it is costing the prosecution a lot. It has cost 1 year delay already in the case because the criminal matter cannot continue in the absence of the accused person ordinarily speaking. I'm going to explain that. So everything is on hold. Now, another issue, the shorties. We're trying to get the shorties. But sometimes you see the documents sent in by the shorties are not properly verified. The courts usually order that either the court registrar or an officer of court should confirm that these shorties are who they say they are. But sometimes, the Nigerian factor, these details, they don't go to details. Where is the house? Have you seen where the person resides? Or they give fictitious addresses. So we're finding it difficult to even locate the shorties, to trace them and get them arrested for them to produce the accused person. So the other day, the judge said, this kind of case, is not likely to release another person on bail for such a case because it has delayed the case. So that's part of the problem you have. Now, the CJAG has made provision for the courts to register corporate organizations. Sorry, there was an interference here. So if you have corporate bodies providing such services, then I think it would be easier for the courts to rely on the bondsmen, the sureties they provide in order to release persons on bail. So that's part of the problem. Now we also have cases of politically exposed persons, people who have a lot of influence when they are released on bail. Now, let me recount something. We had gone far. We were virtually at the end of the case, and we had an investigating police officer on the stand being cross-examined. At the point, of course, something happened, something changed. I stepped out of the court and I had my junior just take it. Something changed. A very good police officer changed, did a 360-degree somersault on all he had said in the course of the trial. And the judge was so upset. He immediately discharged and acquitted one of the suspects. And he was saying, so why did you tell us something different all the time? So you mean you didn't really have an evidence against this young man? But you said that. So I took the pains to look for the officer subsequently and asked him what happened. I know you are better than this. He told me, Madam, I was being threatened. If I didn't do that, I would have lost my job. There were highly placed persons involved. So this is the kind of pressure that witnesses come under when you have highly placed persons that are involved in some trials. So when you see the court sometimes do not grant bail to something, especially politically exposed persons, they look at a lot of the dynamics. They also look at the prevalence of the offense in the society. there was a time it became the fad for people, inmates, to say, just take me to court, because they would find a way to get out and then leave, then go back, commit the crime, and come back again. But another thing I've also experienced concerning bail is depending on the case. I had a community case involved community clashes, 2 communities, and then the person that was prosecuted, they kept asking for bail. We opposed it for a while, but after some time, the judge granted him bail. By the next adjourned date, the man was not in court. We made inquiries. Why is he not in court? We learned he had been killed. He went back to the community. The place was still hot. The opponents saw him and they killed him. So that was how the case ended. So sometimes when people are not granted bail, it's also for their protection, depending on the kind of case involved. So that's why we're talking about, circumstances of the case. So antecedents of the defendant, is also part of it. There are lots of reasons why bail is not granted. Now, let me just, before I round up, talk about the issue of the onerous conditions for bail. Onerous conditions, I would say straight up that there is also provision for review of bail conditions. If the bail conditions granted by a judge, they are way too onerous, they're too high, of course, the lawyer can also make an application and give reasons why the bail conditions are too high and they should be reviewed. They should be reviewed. If you're able to make a good argument, then of course the person can be granted bail. So I should say straight up too, sorry, I should say also that it is not in all cases that persons are asked to make a deposit, for bail. Sometimes the amount for bail is just on paper. It's the amount that the trustee is going to forfeit in the event that the person, that the defendant or the suspect runs away, it cannot be found or jumps bail. So the trustee is brought in and is asked to show cause why he should not be committed. So he could forfeit the bail bond. Some people don't mind actually when the amount is low. They don't mind forfeiting that bond just in exchange for the freedom, of the person who has gone out. But something else that I know that an innovation in the ACJ though is at the point of applying for bail, at the point when bail is being granted, the judge, there's provision for the judge to warn the defendant that if he absconds, if he jumps bail, the trial can continue in his absence. The trial can actually continue and get to the end in his absence. So it will wait for him whenever he's apprehended. He's going to have a judgment against him. But the judge must have warned, not have advised, must have informed the defendant of this at the point of granting the bail. So it's something that prosecutors should also try to draw the attention of the court. So there are a lot more, but I know we don't have so much time. So let me just quickly take on one or two of the issues raised by Prof. Why do we have so many persons awaiting trial, when the Constitution and the law has provided, provisions for bail? There are lots of reasons why people are in trial. First, you have lack of awareness. Some people do not know that they can actually go and apply for bail, even while in police custody. The lack of awareness. Then we don't have enough maybe lawyers that are taking up these issues. Some are trying. We have a lot of lawyers in pro bono, but a lot more can take up these cases. That we also have issue of delay. Yes, we have that delay at different points. We have so long as government is involved, there's a lot of that delay. Files moving from one place to the other. Funding of the judicial sector, the Office of the Director of Public Prosecution. There's a lot that is required. I know there are timelines, but funding is a major part of the delay because you may not have enough manpower, you may not have enough equipment, to prepare all that needs to be done for the process, bail application process to go smoothly or go quickly. Of course, you have overloaded dockets. The court, some of them have overloaded dockets. So they can only take, such number of matters in a day that are required. So those are part of the reasons why we have persons awaiting trial. Then lastly, the issue of bail really different organizations, different agencies handling it, arresting agencies. They are all subject to the authority of the Attorney General. The Federal Attorney General and the State Attorney General can, within their jurisdiction, take over any matter that is before any agency. So cases can be reported to the Attorney General if it's been investigated in the police, or you suspect there is a delay or something is going wrong. People can actually apply to the office of the Attorney General, and he can call for the case file, and call for a report on what is going on in the investigation. So the Attorney General can take over any case at any level from any law enforcement agency. So there's a lot more, but I think I'll stop here right now so we can take questions if questions that may come up. Thank you very much.
Thank you very much for that. Yes, no, I think you have covered a lot, and for me, raised the issues that even the police face in terms of addressing bail and what the judge might take into account. For example, the identity of a surety, and how are you sure that they are telling you who they are and their locations? And I suspect that some of these issues are actually beyond the capability of the criminal justice practitioners or the courts, because as to whether a property belongs to a surety, really that would be something for a land registry. Well, it was interesting also what you said about the politically exposed persons and how the police are threatened, because sometimes the perception is that the law enforcement is all powerful, but what you say, there are others out there who can influence, how the police prosecute cases. So thank you very much for that. I don't know whether Bulus whether you're ready to throw, you're ready.
Yes, I'm here.
Good. Thank you, Bulus. Yes. The intention was to have, the judicial input, but I think my colleague is facing difficulties. So, if you don't mind, starting now and just telling us about your perspective, especially as a defense lawyer. Thank you.
Okay. Thank you, Mr. Akinyanju, for inviting me to speak on this program. First, let me start by congratulating Criminal Justice Advisory Group on its 1-year anniversary and the much that it has done to contribute towards criminal justice administration in Nigeria and the world over. So about the topic being discussed, is bail free? Dr. Iyabode has given us the conceptual definitions and descriptions of what bail is and the basis upon which bail is hinged. It's predominantly a constitutional thing, which hinges on the right of every citizen to personal liberty. And that right is sacrosanct, except in circumstances provided by law. But talking about whether bail is free, it would appear that it is talking on the issue of administrative bail. As Dr. Iyabode has identified, we have different kinds of bail. The common ones are the police bail and court bail. She also talked about a bail being granted by government agencies like the EFCC, NAPTIP, ICPC, NDLEA, and a wide range of other security agencies. However, administrative bail is usually granted where either where a person is arrested, either with or without a warrant. Now, the Police Act, the Constitution, and the Administration of Criminal Justice Act, in the case of Abuja, and the law in the case of other states, provide that a suspect may be granted bail where investigations are still ongoing. However, that would appear to be one of the problems that we have with the administration of criminal justice as far as the police and other investigating agencies are concerned. You know, in Nigeria, you often find out that investigation is always commenced with arrest. Ordinarily, one should be investigated, and where a prima facie case is established against such a person, then he or she may be arrested, in which case there's enough evidence to charge the person to court. However, that is not always the case. There are circumstances whereby a person may be arrested before the conclusion of investigation. Now, in such cases, that person should enjoy or should be granted bail as the matter of right. And again, the reason has been stated by the doctor who spoke first, and that is to the fact that every person is presumed innocent until his guilt is proven in a competent court. And I believe that at the stage of investigation, the suspect is equally presumed to be innocent. So he should enjoy bail as a matter of course. In fact, he needs not to apply for bail as it is often practiced in our police stations. I had calls to accompany some chief magistrates in the FCT to perform their oversight function. And whenever they ask some police officers, why is this person still detained? You often hear excuses like, he did not apply for bail. And the magistrate will be like, no, he needed not to have applied for bail before he could be granted bail. It is your duty as the officer, after assessing the situation, after assessing the case before you, to determine whether the suspect should be granted bail or not, as in the case of a capital offense. So if the offense alleged is a capital offense, of course, the police cannot grant bail. It's only the judge of the High Court that can do so. I also wish to talk about a point that was raised by Dr. Iyabode in the course of her presentation. She made reference to, I think, section 63, sub 1 of the Police Act 2020. There's a portion there, if you may allow me, I could read it here. It reads, where a suspect is taken into custody and it appears to the police officer that the inquiry into the case cannot be completed immediately, he may discharge the suspect on his entry into a recognizance with or without surety for a reasonable amount to appear at the police station in such times as are named in the recognizance, unless he previously receives notice in writing from the police officer in charge of that police station that his attention is not required. The main portion that caught my attention is with or without surety for a reasonable amount. It's crazy that, one didn't really avert his attention to this aspect of the Police Act until today. To my mind, I think that is absolutely unconstitutional, because to some extent, it kind of presumes the guilt of the suspect. It highly prejudicial that the moment the suspect is before the police and the police has not completed his investigation into the matter, for him to release such a suspect on bail, that suspect will need to more like deposit a reasonable amount, whatever that means. You know, that is highly prejudicial, and I think it's something that we need to take a critical look at, and if possible, take some action in that regard. So that would be for police bail. Talking about court bail. Talking about court bail, to a large extent, as Cordelia has pointed out, it's at the discretion of the court where certain conditions are met or satisfied. Now, it will appear that over a period of time, the police and other investigating agencies appear to have borrowed unconstitutionally, borrowed leave from the court to the extent that they now grant bail with conditions. EFCC, for example, will require the suspect to deposit his international passport, to produce sureties who must be civil servants of grade level 15 who have landed properties in Maitama, Asokoro, and all sorts of crazy things. You know, we can confidently say that these agencies do not have the powers to do all these things. Quite unfortunately, it will appear that the court has or is empowering them to continue in that error. Earlier in the day, I read a news item. It's a report of a case, of a judgment that was delivered by the Court of Appeal. And, you know, the judgment is to the effect that the EFCC, in the course of investigation, can arrest and detain suspects. And I think that is an anomaly. It shouldn't come from the court. These agencies go about violating the rights of individuals without they do that without blinking an eye. The court should stand between these agencies, between the brute use of power and citizens who are largely unprotected. However, we don't see that happening in most cases. In quite a number of cases, it's almost like the court is more aligned with the arresting and detaining agencies than they are with citizens. And no wonder we have such a large number of awaiting trial inmates. We're talking of more than 50,000 citizens incarcerated and awaiting trial. At the end of the day, the judgment of the court will go either way. If the court will hold that they are innocent of the charges being brought against them, who pays for all the periods that they have been in detention? I mean, we are in a country where citizens whose rights are violated rarely get remedy, rarely get compensated by government agencies who use such powers arbitrarily. You know, so these are things that should really agitate our minds as citizens, as criminal justice administrators. We should find ways of cushioning the use of force against citizens, you know, helpless citizens to a very large extent. If the law comes harshly on criminals, you know, that would be a good development. I mean, looking at the example that was cited by Cordelia in the course of our presentation about the police officer who was threatened by some bigwigs who were being charged to the extent that they were let off the hook. You know, those who commit crimes at the end of the day are set free, and the innocent are the ones who suffer. No society, no country can progress with this kind of system. And it devolves on us as administrators of criminal justice to explore a proper solution to all these anomalies. I will stop here pending any further needs or comments from you. Thank you.
Thank you very much, Bulus. I mean, as you say, it does raise a lot of questions regarding the constitutionality of the legislation, especially the Police Act, which maybe in some respects is meant to perhaps modernize administration of criminal justice. I have actually looked at that piece of legislation myself. But like you say, asking a police officer to determine what is a reasonable amount, I think, yes, it is highly subject to abuse. Yeah.
Sorry,
yeah.
You know, let me just say, I think there's something, if I heard him correctly, you talked about entering into a recognizance, a reasonable amount.
Yes.
I think we should try to draw a distinction. There's a difference between depositing the amount and entering into a recognizance, meaning that you're going to forfeit that amount in the event that you do not show up. That if the person doesn't show up, he forfeits that amount. If the suspect, does not show up. That is not to say that people are not being asked to make deposits of sums. That is also going on. But I just thought we should just have this.
The distinction. No, thank you for that. Actually, on that point, and like I say, sometimes these are questions for the police. With the deposits, I suppose what cash is collected, or is there a bank account, or does anyone know how that actually works? Bulus, do you have any experience of that?
Sorry, come again. I didn't get that.
So, I was talking about the deposits, that is, as opposed to the reconnaissance and the surety. If the decision by the police at the station is to collect a deposit to ensure that the suspect comes back to the station, or maybe appears at court, perfectly reasonable. How does that actually work? Is there an account that money is paid into or collected at source, or have you experience of that?
Okay, so in the case of the court, it's usually a bond that is entered by the sureties. However, I think 2 weeks ago or so, I received a call from one of our members who said that he was at the police station to secure the release of his client, and that his client was asked to pay, I think, about 150,000 or so. I can't really remember right now. And it jacked my mind. I was like, where did this emanate from? Where did this come from? But looking at this section of the Police Act, you begin to appreciate where the misconception emanates from. Now, we have a police force at the lower cadre that is made of persons who are not well schooled. So reading that aspect of the Police Act, the common interpretation they will draw is that gives them the power to request for payment of some money. in the process of applying for bail. I mean, this has been the challenge even before the enactment of the Police Act 2020. So to the minds of some of them, this would appear to be giving them statutory backing to charge such sums. However, Dr. Iyabode has rightly pointed out, the recognizance reference in that section is basically a bond undertaken by the shortee to produce the suspect whenever he or she is needed at the police station. But even at that, I don't think that the police should have such a power. That power should be within the purview of the courts. Giving the police such wide judicial powers will likely occasion serious breach of rights.
Yeah, it's always a difficult one. In fact, when I recollect what Cordelia was saying sometimes about sureties and producing landed property and so forth. Even that from now I'm speaking from what I've experienced in the courts, even in the UK. And for example, there's a recent case where the suspects were in court for supply of Class A drugs, and by that I mean like cocaine, heroin, and such drugs of large amounts. And their defense team, and there are about four, 5 co-defendants, and the defense team was saying, please grant clients bail, and they were putting forward, and I think one of them said, my sister can not only stand as surety, but can pay as a deposit. In England, it's called a security. So you either, like you say, have a surety or a security, which I suppose is the equivalent of a deposit. So he was saying that his sister could come up with £10,000 cash to be deposited straight into the court, and that means if he's released on bail, he would turn up at the next hearing. That's an assurance that he's not going to abscond. And the next defendant also too had a sister or somebody in the public gallery saying, "Oh yes, I can offer this large sum of money." But I think what actually kind of raised even more suspicion were that these were persons that really had no proof of income. And you think, where is your family member able to come up with such a large sum of money that they are saying, the court even hold on to this money for the duration of the criminal proceedings? So it actually kind of raised questions and red flags as to, the true identity of, the persons putting forth the money and really how they had raised the money, because this is probably money from proceeds of crime. So if they're prepared to, forgo that sum, or at least put that money into the court system, it begs the question, how much money that is unaccounted for do they have? So I think bail is never an easy subject, even for the judges and police, because it's always a balancing act. Because, like you say, you want the suspects to be able to turn up, and other considerations such as likelihood of tampering evidence, especially because of their positions in society. I will just see whether we have a fourth speaker. I know he's been having difficulties coming on. I'll just see. Emoji, are you there? And I know he had sent in a video. Will the video assist us? Or I don't know whether CG, you've been able to join us. I'm just looking through the list of names. It does not seem that that is the case. Perhaps I can ask, even I can start with Prof. Is there any kind of interaction with, I don't know whether, and if I take Lagos State as an example, so for example, I'm aware there's a law commission. Is there any interaction maybe with the academic community or legal practitioners when they are looking at laws, whether it's, as you say, the administration of criminal justice law or even this new police act? I just wonder whether there's any kind of collaboration between agencies when new laws are being considered, and what your experience is of that. You're on mute.
Okay, thank you, Mr. Akinyanju, for that question. Nigeria is, we have so many things that you could look at. Nigeria is a federal state. Nigeria is, what else can I say now? Nigeria is a federal state. Nigeria practices division of powers. We have the exclusive legislative list, concurrent legislative list, and residual legislative list. We also have the area of international law and the domestic law. What is the position, international law and constitution, what is the position, and so on and so forth. But what we are talking about now is in respect of offenses. So in Nigeria, we have 3 legislative lists. And for the exclusive legislative list, all the items there, the federal government can make laws regulating offenses on all the items on the exclusive legislative list. So any item that is not there, also the states can make their own laws. So what I'm trying to say is that you have criminal offenses. Of course, if there are offenses that falls under the exclusive legislative list, then the Federal Act will cover it. It's now left for the state to also make their own, offenses. So you can say that states can legislate on offenses generally, but for all those items in the exclusive legislative list, it's only the federal government that can make laws in respect of it. So coming down now, you have the ACJ, Administration of Criminal Justice Act. It will only apply in Abuja because it regulates federal offenses. So it's left for the state to now adopt it as their own laws. And that I said that about 18 states have adopted the ACJA as their own law. So that means they can use it in their own states, having adopted it as their own laws. The same thing with the Child Rights Act, even though you also have the issue with children not being the exclusive legislative list, and it falls on the residual list automatically. So what I'm trying to say is that when it comes to offenses, of course, we have the criminal code, we have the penal code, which are federal act. We also have states legislating in the various states. Like for instance, we have the criminal law.
Can you hear us, Prof?
Maybe it's reception.
Yeah.
Okay. But if you don't mind, perhaps while we're waiting for Prof, let me just keep this in concerning, is that okay?
Yeah, please do.
Okay, while we're waiting for her. Concerning interagency cooperation, when this are being passed, all the houses of assembly all actually have provision for public hearings. So not just interagency cooperation, the public is supposed to have an opportunity to make an input into the laws, that before they are passed. So if the houses of assembly, the National Assembly or the State Assembly, if they actually observe, this provision concerning public hearing or bill, then you see that, and then publicize it as much as possible, send it to various agencies, stakeholders that will be affected by the law and be passed into law. Then they can get input that they can use to come out with a document that will be, properly fine-tuned, the document that will represent the interests of everyone. But unfortunately, sometimes we have a lot of these laws being rushed through the assembly, the houses of assembly, not given enough time for stakeholders to make their input. We also have sometimes the bills are even sent to some stakeholders who ignore that. They may not bother to make their input, to make a representation, presentations at the public hearing. Sometimes they don't bother. And when you have that, they ignore a lot of things will come out at the end of the day. When it's been passed into law that people start looking at it. And I must say also that some houses of assembly do not make use of their legal department. They have legal departments that advise them, on the legality of some of the laws, the position of some of these laws, whether they have similar laws or whether a law is actually tenable. But sometimes they ignore the in-house counsel judgment and rather opt for private practitioners, that draft this law and just give it to them. They want it passed the way they want it passed. That's the political aspect of the whole thing. So at the end of the day, when the law comes up, you start seeing flaws. And that is why that's why we have a lot of laws being amended, shortly after they have been passed, because there was no due diligence and proper interrogation of the bill before it was passed into law.
Yeah, no, thank you for that. That's understandable. Yes. Is it any better with the states? I mean, I appreciate that with the states, they are adopting the federal laws. Isn't that right?
The states are adopting the federal laws. They amended. They are liberty to amend some sections of the law, like even the Administrative Criminal Justice Act. I know in Rivers State, for example, they have reduced the timeline for certain activities, certain actions to be taken. Talking about DPP's advice, where they ask is maybe just about 14 days or so to the Director of Public Prosecutions to give his advice. The state to give 8 days. Trying to make things a bit more speedy, faster. So the states actually have the opportunity to amend it to suit what they feel is their peculiar circumstances. But ultimately, the same assembly and the same practices take place, both at the national and at the state level.
Yes. Thank you, Prof. I see you are back on now. Yes.
Sorry, the Nigerian factor.
Yes. No, and I think you were talking about the constitution and really its effect on lawmaking for kind of criminal offenses. And Cordelia was explaining about sometimes how laws are passed with haste without perhaps not enough consultation with various stakeholders, whether prosecuting agencies, universities, Nigeria Bar Association, and so forth, to name a few. Yeah, I think there's a question on the chat. I'm just trying to see whether I can get hold of it. Or
so if I can add to that, to what she said.
Yes.
So you have our federal characteristic, our federal structure being a problem, in the area of criminal justice, even with Violence Against Persons Prohibition Act is all the same thing. So you see the federal law being made, then it becomes, you have to sensitize, you have to do a lot of advocacy before you even get the states, to adopt it. That is one. Then if the law is something that is a little bit sensitive, like issues of children and women, you have a certain part of Nigeria that will not even adopt, that law. So in essence, that means that provision that you're talking about, the protection, will not even cover those who are living, in those areas of Nigeria, especially the northern part, when you're talking about children and women now. So in talking about, that is the structure of Nigeria. So when you're not talking about people, are people consulted? I think for Lagos State, they do a lot, but for other states, I don't know what is happening there. Then I also see this trend that we must talk about in terms of international donors or international partners coming up. They do a lot of piecemeal. As they are coming to Nigeria, they already have the aspects they want to spend their money on. So when they come, they just say, okay, this is what they want. Even when you are saying, these are the problems, let us look at it this way. But they just do it their own way. And at the end of the day, you don't see any synergy. Yeah. For instance, we have something that we're working upon now that we're looking at. But I saw that it's talking about violence against women. You understand? But in looking at it, I saw that NGOs have done some work, some guideline, this and this and this, but they are still coming and they are saying this is the way they want to do it. So the starting point will always be, because we should say it now because this is an international forum, the starting point is to know what has happened in Nigeria. What have we done? Where are we? Then from there, take it up and help us to complete it. Not that we just be coming with whatever you want to do. So you don't have synergy in all these issues of law enforcement, sensitization, advocacy. There is no synergy.
Yeah.
So, yeah.
There's a question from Tosin, and just bear with me. It says, the idea of bail that I have so far is an accused person having to pay a sum to be released. I wanted to know if there's any case or scenario where a person would not be required to pay any amount at all. Maybe I could put that to Bulus. Are you still with us?
Okay. Okay. Before I respond to that question, I wish to add that in addition to Abuja, the Administration of Criminal Justice Act also applies to federal courts and federal agencies that are domiciled in the state. So it's not applicable to Abuja alone. And then coming back to the question asked by Oluwatosi, it's just unfortunate that the law is being applies in reverse order. The position of the law is that bail is free. Administrative bail is free. Same thing, court bail is free. One needs not to pay anything. The only scenario in which money is contemplated is in the context of a bail bond in the court, and then now the Police Act has empowered the police to also get an undertaking from the sureties. But citizens or suspects are not required to pay any money in order to secure their release on bail. If that were to be the case, then it wouldn't be any different from what the bandits are doing. It would be more of a cheat now.
Yeah, no, that's I suppose it begs the question, how much of the law do the police know? And especially new legislation, we're talking about Police Act 2020, AJCA 2015. So perhaps wearing your NBA hats, and maybe if I could direct this to especially Bulus and Cordelia. Any engagement with the police or with law enforcement agencies, but of course with the police being the primary law enforcement agency. What's the NBA's stance on that in terms of engagement and education?
Okay, well, we have quite a wide range of engagement with the police, most of which were initiated by my predecessor, Mr. Folarin Aluko. The NBA has the police duty solicitor scheme, in which the police in the FCT, the Legal Aid Council, and a number of other stakeholders are involved in. That has given us an opportunity to interact with the police on quite a wide range of issues. We equally have the Pro Bono Lawyers Forum. We have a pool of lawyers who offer pro bono services to indigent suspects or defendants in court. And there are instances where suspects or defendants are referred to the NBA by the police, the magistrate, in some cases, so we have that working relationship.
That's good. That's good to hear. That's good. Cordelia, Citizens Rights Directorate. In terms, and I know you can't answer every detail, but in terms of maybe legal information, if I could put it that way, how does that work in Rivers State?
Okay, well, I'm not speaking officially for the Directorate, but just in terms of information, personally speaking, the Directorate is an arm of one of the components of the Ministry of Justice that deals mainly with cases of complaints from the citizenry, and primarily try to resolve disputes and conflicts using the ADRO mechanism.
Okay.
So yeah, a lot of mediation takes place. People come in with their complaints. They are walk-in complaints, and then people can come, their petitions, you can come. Cases range from they have matrimonial issues, you have even things like landlord and tenancy issues. You have corporate, ones involving employer-employee relations. You name it. So long as there are complaints, people can walk in and make their complaints for the directorate to attempt to resolve outside the court. And employing, to a large extent, the ADR mechanism of mediation to see how the parties can drive the process and come up with a resolution that of issues that would actually be agreeable to both of them at the end of the day. There's a contract, more or less signed by the parties. It is actually an interesting role, somewhat different from my previous role, in prosecution. But at the end of the day, it's another way of resolving disputes other than going to the court. Some of us that have been in court, for several years, over 25 years now, you know that it's not everything that can be resolved, in the courtroom. So this avenue is also good that the government creates an avenue such as this to get people to be able to resolve these issues, also help decongest the court. And if you do that, I think it actually helps everyone in the society. So I'm doing more of mediation now, more of mediation than prosecution. Although, of course, if they have a bit of that, some cases we're following up.
No, thank you for that. And in fact, I'm trying to think back, but I think there was some kind of idea being developed by the late Justice Bagore, even for, could have even been for minor criminal offenses, because I can remember, I think Professor Onwusu of the law school was a great promoter of that a way of resolving probably minor issues, which if they were allowed to go through the court system, like you say, because of the adversarial nature involving the police and so on and so forth, in any common law. I'm sorry?
Sorry, please. Sorry,
Right.
I interjected. I said the plea bargain in criminal cases. That is also
yes, I think it was a bit of a plea bargain, but also yes, and also cases where so if there's a loss as a result of a criminal act, how that loss could be compensated. And yeah, I suppose one could put it in the ballpark of plea bargaining. I mean, in the UK, they introduced something called a deferred prosecution order, and these were really for kind of corporate crimes where you weren't really proving intent, but maybe like kind of strict liability crimes. Maybe that could have arisen from, say, breach of a regulation. A particular case in point was where a parent company was found guilty of not effectively monitoring the subsidiary that had been involved in criminal activity. So, for example, it was a case of a Standard Bank, and the Standard Bank, I think in Tanzania, had been involved in bribing some government officials. but the case that was brought against the Standard Bank in the UK as a parent company, and I think even there's maybe a Chinese a company has some interest or some shareholding in it. But the parent company in the UK was being prosecuted for the acts of the subsidiary in Tanzania, even though the parent company had not been involved, like I said, in that criminal activity, but because there wasn't proper oversight, then they were prosecuted. And as a result, they said this deferred prosecution order, and it was that, well, if you can demonstrate maybe for the next 3 years that you're going to keep your house in order, you're going to ensure there's proper training and monitoring and so forth, then you would not have to pay a substantial fine in the UK, because as a company listed under the London Stock Exchange, they are liable for whatever happens in the rest of the world. And it's funny because that company also is listed under the New York Stock Exchange. So the American authorities had prosecuted them as well. And so they were able to do this form of, I wouldn't call it a plea bargain because it hadn't got to conviction yet, but it was a kind of device to say, if you keep your house in order, then we will not prosecute you. If maybe after 3 years, we see there's been no improvement, then we might bring the case back to court. So yes, I think that there's a move now across the board to kind of find, alternatives to straight conviction and sentence and so forth. But with any of these things, including plea bargaining, it needs very strict guidance so that it's not abused. Because what will tend to happen is I think, as we've discussed earlier, those with the wealth and means are the ones that would benefit from it, whereas the poor person on the street, the indigent, would not have any of these provisions available to him or her. But I think looking at the time, that actually brings us almost to a natural end. I will just see whether there are any other questions, and I don't think there are. Before I round up, I just want to mention about about my next event, the next CJAG event, which I'm planning for the 3rd of December. And this is going to be on family law, and it's really trying to address family conflicts. So every year, which tends to be the anniversary of I think prohibition against violence against women and girls, and usually in the past I've held seminars on domestic abuse. What I'm trying to do this time is bring some speakers who are going to be talking about reducing conflict within the family, and hopefully that would ensure that arrangements for the children tend to run smoothly. In the family court that I am in the UK, we deal with arrangements where when parents have split up, and who does the child live with? Child live with dad or live with mom? And if, for example, child is living with mom, how often does the child see the other parent?
Visitation rights.
Yeah. So there are some tools that have been developed by social services something called the Separated Parent Information Program that is being offered to parents. So I've got somebody speaking about that. My other speaker, who is actually based in East Africa, will be speaking about a course called the Alternative to Violence course. And really it's about educating parents about, how to deal with issues of anger management and, kind of keeping issues that do not degenerate into violence and means that somebody ends up in criminal court or even in the family court. If violence is proven, it means they cannot see their child. So I thought that would be a different slant to, just dealing with the straightforward domestic abuse issues. So, so that's 3rd of December. I'll be sending out further information, during the course of this month on that. And I hope you'll all be able to join me then. And I think other than that, I just really want to thank the speakers, Professor Iyabode Ogunniran, Mrs. Cordelia AK, Mr. Bulus Atsen, and I don't know the 4th speaker, like I said, unfortunately, he could not come on. But thank you very much for giving your time and having this very engaging discussion and information on bail and the law. Like I say, it would be recorded and available on YouTube. And I hope really it will elicit more information in the future. And I would really like to have, legislative members on board, members of law enforcement and so forth, so that they can even discuss with us, how they perceive lawmaking or even the challenges they face as law enforcers, because we are all stakeholders in this justice system. So thank you all participants that have, like I say, you've given up a Friday evening to participate from Nigeria, the UK, the Caribbean, and even further afield. And I wish you all a good evening and good weekend ahead. Thank you.
Thank you very much.
Thank you, Val. Thank you, everyone, for joining. Have a beautiful weekend.
Thank you. Good night.
Good night. Bye.
My email address on the chat box, cjaglaw@gmail.com. So do get in touch with me